We have some new court filings, but before that, I want to talk about Sarah Boone's appearance in court because she began very smiley, seeming kind of happy, and that was wiped off her face by the end. So all of Sarah Boone's previous pro se motions are abandoned, and the motion from her lawyer to continue the case that this was all about is denied. The schedule will remain, and her attorney can appear virtually for future appearances. One of the experts the new lawyer wants was actually used in a previous case in Florida successfully to argue battered spouse defense in a case where, if I'm remembering correctly, he said that a woman shot her husband who was laying on the couch. Her lawyer says they don't have time to have the experts meet Sarah Boone in the time frame before the battered spouse defense deadline. There's only 6 days. So basically, he can't file this motion unless he knows he's going to use it, and he can't know if he's going to use it until he has these experts meet her, and there's only 6 days. It's not enough time. So he wants a delay to the end of the year or start of next year. He says he has problems with the police interrogation as well. The state argues that her previous lawyers have investigated this defense in the past, so they're against the delay. The state wanted to wait a week to see if, the defense has anything new that might, explain a delay. But the defense, of course, has to mention, we can't wait a week. We only have 6 days legally to file this defense. The judge says, essentially, that the defense lawyer knew what he was getting into. Sarah Boone is the reason Sarah Boone is in this situation. That the lawyer knew when he took on this pro bono case there would be no delays for new counsel. And there have already been many previous experts. And the judge seemed ready. He listed the experts who had seen her, who were experts in battered spouse syndrome. The case has already been continued 16 times. The judge says that the lawyer has time to file within the required time. Her lawyer tried to argue that he needs to review digital evidence as well, what Sarah Boone had on the USB, essentially. He said the jail wouldn't let him bring in his laptop to view it, if I'm remembering correctly. A lot of this is from memory. I was listening to it while I was trying to prepare other things. He believed Sarah Boone was supposed to see it in person with a state investigator, and they were supposed to go one by one through each exhibit. And instead, she just got a USB. So it's actually a violation of the court order by the state. The judge explained that there was a hearing after that, modifying it for just the USB drive. And at this point, it sounded like it was kind of over. No more continuance, and they'll just review it before trial. Now, there are motions filed. So this one is for a statement of particulars. And I'm not going to read the case law here, but I'm going to explain basically what they're saying. They're saying that the information she has been given fails to inform the defendant of the particulars of the offense sufficiently to enable the defendant to prepare a defense. Basically, the requirement is, and I will read this part, the rules require the information on which the defendant to be tried shall be plain, concise, and definite written statement of the essential facts constituting the offense charged. Basically, they're saying that the statement of facts is not concise enough, and they want it redone. So that's one thing they're asking for. Again, will this cause a delay? Can they use this to argue for a delay? Maybe. Maybe that's the point of this. We have additional discovery. This comes down to defendant by and to the underside attorney under the rules 3.22 FF. Under additional discovery on showing of materiality, the court may require such discovery. Specifically, the defense is requesting the Office of State Attorney provide the written policy of the Orange County Sheriff's Office relating to in-house interrogation procedures, in particular the policy in place at the time of the interrogation of the defendant at the Orange County Sheriff's Office. So I've not shown this interrogation footage on the channel, but it sounds like, from listening in court, that her new lawyer wants to use that footage kind of to say that they interrogated her improperly. There were some things they were objectionable. Maybe some things that he could try to get so the jury can't see parts of that interrogation or all of the interrogation. That's my understanding here. If he does have particulars there, I might have to do a video showing those particulars and his arguments. I assume that if he has particular moments he doesn't like, he'll be detailing them in a motion. And then, of course, because this interrogation is all over the internet, we'll be able to go and take a look at it and see exactly the moments he's finding objectionable, or at least claiming being objectionable. But we'll see if this actually materializes into anything, or again, is this going to be more of a delay tactic, try to get a continuance. I feel like his main goal after listening in court is a continuance, because when the first continuance was denied, he tried for a continuance based on the fact he needed more time for his experts. When that failed, he tried to have a continuance based on the digital evidence. And it seems like continuance is going to be constantly tried, which makes sense. He only has a very small amount of time to prepare for this case. He has other cases to handle. And, I mean, this is a big case, not much time left. And I don't think Sarah Boone, when she was reviewing this evidence herself, was really, I don't want to put this, that helpful for her defense. I don't think she really had anything to go off of. Now, here is the motion to appoint forensic psychologists. Now comes the defendant by him to the undersigned counsel and moves his honorable court for the appointment of due process provider, charged with second-degree murder, is previously found indigent. The undersigned attorney is privately retained and requests assistance of a forensic psychologist and is financially unable to hire. Defendant requests the court appoint Dr. Julie Harper, is requesting been paid in other court-appeared cases a rate of $200 per hour. So if I'm remembering right here, Julie Harper's actually been used in this case before. This is from something that was mentioned during the actual trial appearance. So the court appearance. So they don't think that the organization, I forget the exact acronym, that handles like these payments would be against it, but they also didn't appear for this hearing, so there'll probably be another hearing, or they'll have to, or maybe they'll just submit that they're okay with this because she was already approved for, I think it was like $10,000. I think it was the number. But they want to bring in her. But again, if you're bringing in the same previous expert, if this is the previous expert that I think it is, because they did mention bringing in a previous one. If you're bringing in a previous expert, it kind of, I don't know, it kind of hurts the argument you needed more time to me, but whatever. Motion to appoint crime scene reconstructionist and death investigator. So, Dr. Michael Birkland, a crime scene reconstructionist and death investigator, and they're asking for an initial cap of $6,000, $200 an hour. Now, this one, I believe they have to wait for a response from the JAC that handles the money. But yeah, near the end, there was some more looks into Sarah Boone's face around the end of the court appearance. I just want to mention how quickly that smile, that smirk, she was smiling at the start. She was so happy. I think she went into this with her lawyer basically saying, I have bullet points for different continuance reasons, and I'm going to go down them. None of them are my appointment. I'm going to try to get you one. And she was certain she was going to get one. She was certain she was going to get that delay, and she didn't. I will be very interested if we get more inmate notes, because Sarah Boone is, I would assume, no longer getting access to that laptop, right? She should no longer be getting any of that pro se special privileges. And I do wonder if we'll still get any of those inmate notes because of it. Because are they relevant if she doesn't have access to that anymore? I don't know if there's like an order saying she doesn't get access anymore, but I would have to assume it gets cut off as soon as she now has this lawyer officially representing her. If I missed an announcement, maybe there's a court appearance I missed where they specifically said that that's cut off. But then again, maybe we will get some more letters, because maybe she'll end up having kept some evidence or something like that, and they'll want to bring it to the court's attention if the lawyer says they can't find it and it's found in Sarah Boone's cell. So we might get some more information, but I just want to say that maybe inmate behavior is now no longer something we'll get to see. We'll no longer get to see if Sarah Boone didn't eat breakfast. We'll no longer get to see if Sarah Boone didn't shower.